Hi, I'm Dennis Cohen. I'm a family law attorney and a mediator. Spousal support, alimony, how much, how long? Spousal support, most people call it alimony. It's really one of the most hot button issues in a divorce. Fortunately, there's some guidelines to help you decide how much temporary alimony gets paid, and the same guidelines that are used in deciding child support, basically how much each parent earns. But permanent spousal support is really a whole different category. In California, there are 15 factors that the law looks at to decide how much support should be paid. Basically, how difficult is it going to be for the supported spouse to get back in the job market? They have to have training, what their age is, their health, those questions. Everyone wants to know, how long do I have to pay alimony for? In California, the law says it's the goal that everyone be self-supporting within a reasonable length of time after a divorce. And the law says that if you've been married less than 10 years, that reasonable time is presumed to be half the length of the marriage. There are other factors that can come in to change it, but that's the presumption. California, we say that a long marriage is one for 10 years or longer. And in that case, the court makes a rule that says you're going to pay support indefinitely, meaning until circumstances have changed so that it's no longer appropriate for you to pay support. So is that for a lifetime? Maybe, in cases of someone who might be elderly or have medical issues, never have worked before. It could be you could pay support for the next 20, 30 years. But it might only be 10 or 12 years if the parties are young and the supported party gets a job, wins the lottery. Once again, the factors in deciding how long are also determined by the same factors that go into how much, which is how well are we doing now that we're on our separate paths. So the primary factor in determining alimony is how much is each person making. But what if one spouse isn't working? And what if they're not working because they don't want to pay support? Or what if they're working because they want to be supported? The court, and in mediation, the same criteria apply. You can look at what are the earning possibilities, what's the capacity for this person to earn, as opposed to how much are they earning actually right now. One of the advantages of mediation is that you can look at the fairness factor. Someone who's never worked before maybe wouldn't be obligated to rush right out and get a job. On the other hand, someone who's young and healthy and has work experience, it's really fair that they do have a job, unless there's some medical condition or something making it more difficult. And when someone is unwilling to get a job, that can come into play as well, because it's often appropriate to show what is their earning capacity and what is their earning history. Those are more factors that really come into play when you can look at the whole spectrum of what's fair in terms of support. If you're going through a divorce or contemplating one, do the best thing for yourself and your family. Consider mediation. We know settlement works.